Good morning, everyone. Hello. I will leave some room for people to join, to settle in. We can wait another minute for that. In the meantime, don't hesitate to use the chat box to introduce yourselves, share your names, your company, maybe your location where you're tuning in from. Don't be shy. And also, don't hesitate to tell us what the Data Act means for you. Anything that you want to share, of course. One minute past 9, 16 people have registered already or tuned in, so I'll wait a little bit more. Hello to the newcomers. We're waiting for a little bit more people to come in. Don't hesitate in the meantime to join Vicky in introducing yourselves in the chat. So, what is your name, where you come from, anything you want to share about the Data Act. One more minute and then we can start. All right, let's go. Let's start. For those who've just joined, don't hesitate to put your name, your company, your location in the chat. Don't hesitate to introduce yourself and tell us what you think about the Data Act, maybe. Don't be shy. And in the meantime, we can kick off. So, good morning. I'm Kathy. For those who don't know me, I'm a senior consultant at Dr2. And Dr2 is a public affairs agency specialized in sustainability, energy, mobility, digital and tech sectors for EU and Benelux public affairs. I'm very happy to welcome you today to this final Dr2 breakfast meeting. We had a series then of 3 webinars to discuss the Data Act specifically. Last month in May, we discussed the impacts of the Data Act on energy and sustainability sectors and also on the transport and mobility sectors. We keep track of developments related to data policy issues, and we send out a monthly newsletter. So, which contains the most important highlights from the previous month. So, if you're interested, feel free to subscribe to that monthly update, or you can also get in touch with me or anyone from my colleagues at Dr2 if you'd like to discuss formally or informally what we can do for you, or just have a chat about the Data Act in general. It's a topic that we really like. So you can click on the pop-up that we have here, or just close it. So where do we stand basically on the Data Act? So on the 23rd of February, the European Commission published its proposal for regulation, and it's dealing with business to consumer, business to government, and business to business sharing of non-personal data. And the Commission aims at unlocking the huge potential that data has to offer to the European economy, especially its SMEs, as today apparently 80% of industrial data is never used. The Commission aimed at, writing a horizontal and very balanced approach, not going too much into details, so the regulation would leave enough room for maneuver for those who are in scope. Is that a blessing or a curse? Let's see what everybody thinks today. The Council then depends on presidency priorities, of course, but has generally expressed that data are important to deal with. And the European Parliament, for its part, in there, the relevant committees are discussing competencies and choosing shadow rapporteurs. What we know already, and Angelica, keep me honest here, is that the industry committee is in the lead. The civil liberties committee will lead on specifically personal data, GDPR and privacy issues. Legal affairs committee will lead on IP protection. And finally, the internal market committee on interoperability. So in terms of timing, political pundits expect the initial timeline to slip and do not expect the regulation to be finished much sooner than the end of this term for the elections in spring 2024. So now we are all, I'm sure, very eager to hear from our speakers and how the work in the institutions is progressing, what their perspective is on the Data Act, and what their reaction is to what we have previously discussed in the previous webinar. So it is my absolute pleasure to welcome today Mrs. Anna-Liisa Pärnalaas. She's a Counsellor for Digital and Cyber Affairs at the Perm Rep of Estonia to the EU, and Mrs. Angelica Petrov, Policy Advisor on Cybersecurity and Digital Policy to MEP Alin Mituța, who is Shadow Rapporteur for Renew in the leading committee, ITRE. So Anna-Liisa and Angelica, I will pass on the floor to you in a sec, and following your opening statements, I can ask a few questions to you before opening the floor then to our audience. So everyone who's joined here, feel free to use the chat box to ask your questions, and we will go through them afterwards. Anna-Liisa, you're the first on my screen, so feel free to kick off and introduce you briefly in the way you want.
Thank you so much, and also thank you for inviting me. So yes, I would say that Data, it's one of the biggest files in my digital portfolio that I'm dealing with in the Council, and I would also say that one of the most important ones. And I'm very happy to participate in this series and give a little bit of Estonia perspective on the whole thing. And I'm quite sure that this act has been long awaited by many, and considering its impact, especially on businesses, I believe that events like this are of great importance to really, go into more details and understand a bit better the impacts and what we are about to see. And it also seems that for many people, I would say, working on this field, stressing the importance of data, it has at least a little bit become somewhat a cliche, because we hear it all the time, everywhere. But it is true at the same time that significant barriers still exist that hinder either businesses, consumers, or governments from really unlocking the potential of data in their everyday situations. So if we take a step back, we see that the regulative landscape on data, it's already quite comprehensive, I would say. We have several regulations, some already in force, others still on the table, that address different aspects of data economy from different angles. So in this regard, the recent Data Act is another little piece of the puzzle, or not so little, but it also aims to strengthen the EU data economy. But however, having the proposal out and on the table, it's just a first step. So especially for us, now the work really begins on this very important file. So to start with, I would say that in very general terms, our view is that by having justified and proportionate means and measures in this act, it could have a great potential to boost EU data economy and to strengthen the digital single market, especially considering all the growing cross-border role of digital products and services. And from our viewpoint, the proposal has several strengths. there are many provisions that support businesses to enter the market with new data-based products and services. It also empowers consumers. It enhances data portability, data interoperability, and also offers some safeguards against unfair contractual terms. Also, I would say that the horizontal nature of the proposal is actually one of the strengths, because it allows to avoid fragmentation of the internal market. So this is also one of the overarching objectives of this proposal. But as usual, the key is in the details. So we see that there's still quite a lot of work to do to first understand better its impacts on the data economy, and also to guarantee that the act becomes a competitive edge for our economy and society. And to have that, we need to balance different interests. We have to support competition, innovation, but at the same time, really ensure that data protection, privacy are also in place. So as we see it, preference should be given to measures that help to achieve the objectives, but that at the same time allow a bit more flexibility and do not impose unreasonable extra costs or compliance burdens on businesses, because most of the focus of these measures is exactly on EU businesses. So to foster data sharing within sectors and horizontally, we should perhaps focus a bit more on creating different incentives. And when it comes to designing specific measures, we really feel that it's very important to take into account the real market situation and also practices. Some aspects of this proposal are quite technical, and impacts definitely need comprehensive assessment. This applies, for example, on the technical requirements that we have for making data available. In addition, we also see that articles on cloud switching could perhaps use a critical examination to ensure that it's possible to implement these requirements in practice, and that the outcome is fair on parties on both ends of the spectrum. We also have some concerns on the restriction of on international data transfers, because we definitely don't want to find ourselves in a situation where these restrictions make it more difficult or impose make it more difficult for European companies to access or reuse data from other countries, or also degrade user experience in any way. And to sum up, our long-held view in Estonia, at least, has been that EU should really take an approach to data that is based on creating opportunities, and by all means avoid unnecessary over-regulation. So we really have to, focus and make sure that we don't set up walls for our own startups and SMEs, especially as SMEs with perhaps more moderate capacities might struggle a bit more to understand and follow these constantly growing regulatory requirements. So therefore, what we regulate and how we do it must be very well justified, and it should also be clear for all parties if and how this regulation applies to them. But I will stop here from now and pass the floor on. Thank you.
Thanks, Anna-Liisa. Angelica, feel free to start immediately.
Thanks a lot, Kathy, and also thank you for the invitation. I'm very happy to be a speaker today in this event to talk about the Data Act. In the office of Mr. Mituța, we're now working on two big digital files, and one of them is the Data Act, and the other one is the European Digital Identity Framework. And the difference there, they're not really connected, but the difference between the two of them is that the European Digital Identity really has a big focus on personal data, and then the Data Act has this big focus on non-personal data. So it really shows the importance of how the European institutions are now approaching and giving a lot of priority in regulating both types of data because they both have value, but they also both have a big importance in this field. When it comes to the Data Act, well, the Data Act is generally in the Parliament, we're strongly supporting this proposal because it has come at a very timely moment. It's first of all regulating all of products and services, connected products and services. And if we're thinking about the products and more specifically about devices, we are nowadays having a lot of questions about what data is collected from the IoT devices, the smartwatches, the smart bulbs. For example, the vacuum cleaners, the smart ones, are they recording just the layout of the apartment, or is it more data? Are they seeing what type of furniture we're having in there or not? So these are questions that are probably, people are worried about them. And we as users don't usually have access to this data. Also in terms of the contracts, the privacy contracts of manufacturers, sometimes the contracts are drafted in a very complicated way, which makes it very hard for the users to understand exactly how the data is processed, what type of data is generated, but also what type of data is collected. So on one side, we're having this IoT devices that are developing, and by 2025, I believe it's going to be, it's estimated that we'll have around 30 billion devices around the world. That means approximately 4, or at least 4 devices each of us. So it's indeed something that is affecting us personally, and it's something that we should give priority in the way that we're regulating. Because again, more devices mean more data means more power, but at the same time, it can create more risks if it's not regulated correctly or if it's not regulated at all. And then again, we keep hearing a lot the idea that the data is power. I would maybe say here that data is indeed power, but the reuse of this data can maybe unleash even more potential. It can create even more, it can generate even more profit. It can also generate more competitiveness, but also more efficiency. And here's where the Data Act comes into play. And here's where the Data Act, the role of the Data Act is really highlighted. To maybe mention a couple of more practical things at this point, and then we can get into details at a later stage. One of the major benefits of the Data Act is the fact that it has a consumer focus, and that should be indeed the consumer, the one who should be in charge of the data, who should have access to the data that he or she generates, and to have a possibility and also the right to decide with whom to share this data and if they even want to share this data. So having these principles of access by design is a very welcomed one, and it's probably one of the most fundamental pieces of innovative pieces in this proposal. Also, when it comes to business to consumer, business to business, and to the possibility of sharing the data from between data holders and data recipients, this is leads me to what I was mentioning before. It's indeed something that unleashes this power of the reuse of data. It gives the possibility of companies to improve the way they work and to become more efficient. Also, there are aspects that we can improve here, and we can again talk in more details, but it's the idea of frame contracts and how they're drafted. There's a lot of potential of how they can be improved. There's also the idea of anonymization of data, because when we're transferring the data among companies, we need to make sure that the data is anonymized and that we cannot trace it back. And this is one of our big priorities. And when it comes to anonymization, it's also slightly vague at this point of how this anonymization could take place. And we can also get into more philosophical conversation about what's personal data, what's not non-personal data. But again, I will leave it for later. On the business to government, we believe also that this is a very good inclusion in the proposal, because it has the potential to help in emergency situations. And I will agree here with quite a lot of stakeholders that have approached us to say that it needs to be more clearly regulated. And indeed, it has the possibility of sharing the data with the government has a lot of benefits, but also there needs to be restrictions and barriers for us to make sure that the data is used properly and how it was initially intended. Finally, on the cloud switching providers, it's the right of a user. It's something that we all should have a possibility to do if we want to switch between the cloud providers. There's again ways we can improve these provisions. There are aspects like maybe we should include the possibility of reverse switching of a cloud. So if we decide that we want to switch and at some point to come back, this should also be included in the proposal. So these are aspects all that could be improved, but also aspects that have not been regulated before, have been regulated now for the first time. And we see a huge value in this proposal and in the way it was drafted. I will stop here for now, and I'm sure we can get into more details once we start the conversation. Thanks a lot.
Thanks very much. Sorry, it's still early, up early. Thanks very much to both of you. So I'd like to kick off our conversation by looking back briefly first on some concerns and recommendations that were expressed by our speakers in the previous two webinars, and they were all industry representatives from different sectors. They all agreed with the general principles of the Commission and the Data Act, but they underlined some competition issues that need to be clarified, and you have touched on some of those already, but we can get a bit deeper into them now. So first, supposedly, there would be a disproportionate ratio between the incentives and regulatory burdens that are imposed in the Data Act. The burdens would be much bigger than the incentives. I mean, this is something that you have highlighted, Anna-Liisa. I mean, for both of you, how do you see how can the text be improved in a way that it responds to these concerns? You know, how can smaller players still be incentivized to grow and to digitize?
Yes, thank you for this question. It's a good one. Well, looking back to the previous webinars, I guess we share most of these concerns that were highlighted by the participants, especially the ones related to the compliance cost. And I don't think there is any disagreement over the underlying objectives of the proposal, but I guess it's more about how we achieve these objectives. So what are the policy options that take us from point A to point B? So this is something where we see that we could perhaps make it a bit more easier or less costly for businesses. For example, when we look at requirements for making data available, especially the technical ones, for example, developing interfaces or in some cases making data available in real time, I think we have to have a critical look if all these measures are actually necessary to achieve these the same objectives, or if there are any other better solutions already in the market that we could use here. So taking this into account, I think we are aiming for the outcome that encourages data sharing and builds trust through clear requirements. But at the same time, we really have to avoid creating this unreasonable burden by implementing costly solutions where better alternatives might already exist. So this is something we would like to really address in the later stages of discussing it also on the council level.
Yes, on this question, just concern they probably stem from a bigger issue, and this is probably from the scope of a proposal. The scope of a proposal is very closely linked to certain definitions. For example, we have the definition of a product. Are we talking about mobile devices? Are they in the scope? Are they not in the scope? These are all questions that will influence in the end the data sharing process, but also might increase the costs when the data is shared. To be a bit more specific here, for example, on the definition of a product, we're entering into a situation in which right now from the proposal, if we have the data about the number of steps that an app that collects the number of steps, from a smartwatch, we would be able to download and receive this type of data as users, but also in the end, we can also share the data. And this also falls under the business to business chapter. If we're having this data on a mobile device, which is obviously also saved in there, we cannot, it's out of the scope of a proposal. So in these types of situation, these types of unclarity and uncertainty, we might end up having situations where we're putting additional burden on the companies, because the manufacturers, first of all, they might not understand exactly if they are part of this proposal, if they are in the scope, if they have any obligations, or if they have to fulfill any requirements on how they do that. Also on technical barriers that Anna-Liisa was mentioning before, in the situation of cloud switching, for example, we have the concept of functional equivalence. As long as we're not defining clear what functional equivalence is, it becomes impossible also for the cloud switching services to perform this transfer, this switch. But also it puts, so besides the fact that it puts additional burden on the companies, it puts users also in a very uncertain situation, whether they can switch, to what type of services they can switch, and so on. So these are all aspects that need to be taken into account. All these instances where we're having an unclear text might also put some additional burden on the actors that are involved, and this is something we have to take into consideration and to make more clear. And the list can go on. There's also uncertainties when it comes to what the trade secret is, also to what data is. Are we talking about, again, personal, non-personal, and so on? How do we anonymize data? Do we need standards? Do we need technical specifications? These are all ideas that we might regulate to make it more clear for the stakeholders, but also for everyone involved in the process.
Thanks. Yeah, you're touching on important topics that have been discussed before, that have been, I mean, it seems that more, not only in our webinars, but more broadly, stakeholders very concerned about the protection of trade secrets, that it is supposedly protected in the text already, but the text is not waterproof and should definitely be improved. And you touch upon, more clearly defined definitions. That's something that comes back every time as well. The fact that we need, for example, clear rights and obligations for all parties concerned, for everyone. So yeah, definitely important topics. And given that the time is running fast, I want to incite everyone to please ask your questions in the chat box. We can come to them in a minute. I will share a few questions first with you. For example, on consumers, which has been mentioned as well as being very important. Angelica, you mentioned it as well. This has been the biggest concern basically is that non-personal data may still be linked to personal data. So how do we avoid privacy infringements? How do we ensure this anonymization that you mentioned? Is it sufficiently protected now? How would you intend to improve the texts in that respect?
Yes, so on this data, non-personal data and personal data topic, for example, even a vacuum cleaner, the smart robot that can see the layout of the apartment, only based on the surroundings of apartment, the layout, and the type of furniture that it's in there. This is already enough information for them to predict or to estimate what's the income of a family, how many people might be in that family, and so on. So it's quite a lot of information that for us might seem that it's non-personal data, but because of our algorithms that are evolving constantly, they might be linked to a person. And this again leads us to the conversation that artificial intelligence is evolving. So everything that nowadays might seem to be non-personal data in a couple of years might make it even easier for the algorithms to put two pieces of information together and to link it to a person. That's why the anonymization of information here is key. And when the data is transferred between data holders to data recipients, there have to be very clear rules on how this transfer takes place and how the data should be anonymized. Because if, for example, we will not have clear technical specifications on how we're anonymizing the data, at some point the data holders will just refuse to share data for the sole purpose that they might be infringing some of the requirements from the proposal, which puts on them again some additional burden or even penalties. In giving you some concrete examples or answers to these questions, it's something we are still analyzing. We're looking whether we need some guidance, whether we need technical standards, whether we need international standards or European standards. So it's something that we're now discussing with several stakeholders, but also with the standardization institutions to see what's the best way to proceed. Of course, we will keep in mind that it's a EU horizontal legislation, so we cannot go too much into details into saying exactly how this anonymization should take place. But we can reference or we can make it clear that there's the need for some development, for the development of some technical standards, for example, or some international standards.
Sorry, did you want to say something, Anna-Liisa?
Yes, I just shortly. I also wanted to add that I agree very much that that it's positive that the proposal allows to better represent consumers' interests, but I also share the view that at the same time the privacy concerns related to these new possibilities and you know, that we share more data are quite justified. So we also would like to avoid a situation where, you know, these requirements or possibilities lead to the loss of individual control over the data. So something we're really trying to protect by with GDPR. So perhaps additional safeguards in this regard would be really something we could discuss, and also to make it a bit more clear also in the proposal how the GDPR applies in the context of data, because I guess it's not really clear at the moment. So this could be also elaborated a bit more in detail. Thanks.
Thank you both. I see we have a question from Patrick Geyer at Tesla, who, coming back a little bit to obligations that we touched upon earlier, Patrick is asking the following question. So there are a lot of new obligations on manufacturers in the Data Act vis-à-vis both consumers and third parties. However, there are very few obligations on third parties. Who would be the big economic beneficiaries in the direction of both consumers? Very little transparency related to the purpose for which their data is used and how much money they make from that data, i.e. what the value of it is, and in the direction of manufacturers. So how do you think this balance could be improved so that the incentives to innovate in data generating capabilities remain strong for manufacturers who are involved in an inherently lower margin type of business? Who wants to go first?
I can perhaps start. Well, I guess the big aim of these requirements and making the data available and creating this obligation to share it is to boost competition, to give consumers also more product services to decide from, and therefore to enhance the user experience, at least in some ways. But I agree that it's a good question. I don't have a very good answer today at the moment, but I guess this is also something, where we could really use the input from stakeholders to see that, where do you see that this, if there should be any other, I don't know, obligations on the third parties, in which cases, and how could they, give their input to in total, so that we have a more competitive and stronger data economy. So it would be also very interesting to from our side to hear this perspective.
I will agree here with Anna-Liisa. It's indeed a very good question, and it's something we might need to take into consideration when we're drafting amendments. On the third parties, we might need to have more concrete provisions here. We would have to look into what exactly we're approaching on this aspect. When it comes to the proposal more generally, and we were talking this with Kathy before we started the webinar, it's actually a horizontal type of legislation, and it's affecting a lot of businesses that have the different sizes of businesses, but also a lot of sectors, and each of these sectors and each of these businesses have different specificities, and there are things we have to take into consideration, and these are things that also we need to talk to as many stakeholders as possible in order to understand exactly what are the issues for each of these fields and how we can improve it in this proposal. And indeed, this issue of third parties might need more clarification, and we also might need more safeguards on how this data is being shared, how this data is being processed, and so on. It's something we will take into consideration.
I'd like to switch to unless there's more questions in the chat. I will ask you more political questions. For Anna-Liisa, we know that at the beginning of June, the Estonian government fell, and the parties Reform and Centre are trying to form a new coalition. But we might be looking at snap elections soon, and there's also a general election in March next year. So how do you expect these recent developments to impact Estonia's position concerning the Data Act and maybe other files as well? Related to that is that Estonia is, of course, known to be a very advanced digitized society, and I'm sure that Estonia is also very well placed to share best practices with its peers in the council or even with others. How do you look at that? Does that impact it at all?
Well, you are very well informed. It is true the negotiations for forming a new government are currently ongoing. However, in this regard, I'm not really worried that it will have an impact on our positions on digital files, or including the Data Act or any other that we have, the big ones, for example, artificial intelligence or the European EID proposal. So I'm quite optimistic that we will carry on as we have for quite many years already. Also, the negotiations that are currently ongoing, it's led by our Prime Minister's party, the Estonian Reform Party. So in this regard, I don't see any big clashes between political, so to say, visions or understanding how to regulate data economy. So fingers crossed.
Yeah, good. Well, fingers crossed for sure. We have seen in Belgium when we didn't have a government for a long time that it could, silence Belgium in the council sometimes, that they didn't take a position because there was no government really to take a position. But yeah, fingers crossed and best of luck at national level. For Angelica, maybe a question related to the Parliament. We see now, or it seems that there's kind of a broad consensus about the Data Act so far. So is this going to be a very smooth ride down the line, or do you foresee some controversy in the months ahead?
So indeed, we had one of the first shadows meetings, and all of the shadows have shared their initial views on the file, and it seems that there is a broad consensus at this point on the major issues. Of course, there will be small things like when it comes to defining the concepts. It's part of a process. There will be discussions, there will be negotiations, but from what it looks right now, it seems to be that everyone is more or less on the same page. And also most of the shadows that are working on the file have also been involved in some other files related to data. So either it was the Data Governance Act or the Artificial Intelligence Act, so the DMA and so on. So everyone involved in the process has already a very good understanding of a framework, so it should be hopefully a very smooth ride.
That's good. Yeah, after DSA, DMA, and AI, I think hopefully this will be easier for you guys. Is there another meeting already planned of shadows?
So we are still waiting on the conflict of competences, and that's what you've said in the beginning. There are 4 committees involved. ITRE is a lead committee, but then also URI, LIBE, and IMCO. As long as the conflict of competences is not solved, also the timeline is a bit on hold. But immediately after this conflict is solved, we should have a more clear understanding about when the next shadow meeting takes place. Okay, so for everyone who's still not sure about how this applies to them, they still have time to think about it. And Anna-Liisa, is there anything planned in the council before summer?
Yes, well, as you probably are aware, we have finished the first reading of the text, and we have had quite, I think, 3 workshops that were mainly focused towards capitals. So that experts also on national level could have a better understanding on how this act will play out in the future. So now we are currently in the middle of providing the first written comments to the presidency. So hopefully we will have some discussions in July before we all head to summer holidays. So yes, still some work to be done before, but I expect that the most active part will probably be in beginning of fall, so in September. But we'll see how the current and also the upcoming presidencies are able to really take this proposal forward.
Indeed. I have one final question for you, given that time is running out. To our previous speakers, industry stakeholder representatives, we asked what their elevator pitch would be towards EU policymakers. But to you both, I would like to turn that around and ask you, what would be your elevator pitch to stakeholders? Meaning, what is a good lobbyist? What information is useful to you? What do you like to hear from people and stakeholders approaching you?
It's a very good question indeed. So first of all, I'll maybe use one thing that's related to the professional side. So in simple words, what we're looking for is value and expertise, values and expertise. Why values? Values because in the world generally, we're right now in a very difficult situation. We're facing crisis starting from the energy, climate, and so on. So what we need from stakeholders what is important for the stakeholders and for us is that despite the interests that are being lobbied, to keep also into mind the idea that what we're trying to do here for the regulation is to make things better, and they have to work for everyone, and they have to improve everything that is surrounding us. And the second thing is expertise, and particularly when it comes to technical files or the Data Act in this case. What really helps us is a very niche type of information. For example, I have not known the fact that an aircraft is usually sold separately from an engine. What this means in practice is two different types of contracts, but data is being shared differently. The data falls under two different contracts. So this is a type of information that for us, it's impossible to get from anywhere else, but it's very important in order to understand the full picture and how we can regulate. And particularly in the case of Data Act, because again, it's a horizontal legislation and it affects so many different industries, it's very important to understand all of these very small technicalities that might mean nothing for others, but for us might be very important in order to regulate. So yes, there is an expertise.
Just to add, I think I can align myself quite well with Angelica's answer. So I agree that also for us, having a bit more information from the stakeholders on how these different requirements affect their everyday businesses and practices, and what are the costs, something that might be hidden from us when we read these provisions, but something that really, perhaps makes a bit more sense to them, or they have this technical background knowledge on what are the real effects of these applications. So yeah, having more information on the impacts, but also this kind of constructive feedback. So this means that in addition to flagging concerns, which is always very welcome, we would also very much like to have perhaps more specific proposals or at least ideas on how to make the draft regulation a bit better, or so that it really answers to the needs that businesses might have. So yes, thank you.
That makes sense. Well, that concludes our webinar. I don't see any further questions in the chat, so we can conclude here. And I want to take another opportunity to thank you both very, very much for your contributions. It's very interesting to hear your perspectives. I hope everyone enjoyed it. Feel free to get in touch formally or informally about the Data Act or anything else. Well, not anything, but you know what I mean. And I wish everyone a very, very good working day, and hope to see you and connect soon. Thanks very much. Bye.
Thank you. Bye.
Thank you.